So many people have been shaken by layoffs in the last year.
Yeah.
It's so hard when it happens. It's so hard when it needs to happen. I'm glad that we can start looking at the future for some of those companies that have been affected. So glad we can do this webinar together today.
Yeah, it's a lot of good information to share for sure.
Yeah. And I think in our audience, we have a lot of individuals in human resources at different companies, people ops, and maybe recruiters, also like engineering managers. So there's a lot of people for whom this information is relevant. Of course, even immigrant beneficiaries who are seeking their own green card sponsorship in companies after maybe they have been laid off, but today we're going to be focusing on if the company has had layoffs and how to continue with the green card process. So I'm really excited to get this information out there because just because a company, went through some bumps doesn't mean they don't value their team members. And then retaining your productive team members are even more critically important after that, because you really see how much you rely on them and how much of a difference they make. So glad to do this. Well, let's get into it. Hi, everybody. My name is Sophie Alcorn. I'm the founder of Alcorn Immigration Law. I write for TechCrunch, the Ask Sophie column, and I actually have a forthcoming book, which I'm excited to share and announce. I'll actually put that in the chat window right now for you to see. You can sign up to be notified when it's released, but it's called Ask Sophie, the Founder's Guide to U.S. Immigration, Visas, and Green Cards. And we have some materials in there especially devoted to these topics of like, we're at a company, we need to hire the best people, we need to recruit them, we need to retain them. What are our legal strategies for that? So we've developed all of these opportunities, helping thousands of clients, hundreds of companies with thousands of visa and green card processes over the years. I'm just really excited to be here today. And joining me is my amazing colleague, Linda Haggerty. She's our Chief Legal Officer at Alcorn Immigration Law. And she makes sure our clients win their cases and get approvals. And then what makes her extra special is she also makes sure that our clients get creative legal strategies that work, as well as excellent feeling of customer service. And so I'm grateful that you infuse our whole legal team with those qualities so that all of our attorneys and paralegals, follow in your footstep with that really that sense of excellence for our clients.
Thank you, Sophie. It's my pleasure. It's a great team that we work with. I feel lucky to be part of it.
Thank you. And why do you love working with like HR people and with companies on their immigration?
I just think it's so exciting. I feel like what we're doing, we're really helping people. We're helping companies, we're helping individuals, we're helping the US economy. There's just so many benefits from the work that we do. And there's so many parties involved. And I think the way we shape our conversation can change based on who we're talking to, but everyone has that same goal. So I like the challenges that it brings.
Amazing, amazing. Yeah, it's not for the faint of heart. So it's amazing that we can have this ability to make such a difference in people's lives. Mm-hmm. Thank you. I'm glad we're doing this webinar together today. To our audience, as my deck loads, just so you know, obviously this is recorded, so you can refer back to it. We'll be sending that out. We'll be focusing on a PERM deep dive to get started, and then what to do if there's been layoffs, how to continue with your PERM, how to restart, when to look at other types of green card options. And we are very happy to answer your questions throughout the session, so you can put those in the Q&A panel, which is only intentionally anonymous, so like your name might show up unless you make your name anonymous. So keep that in mind. And we're also available for any tricky or confidential questions. We are happy to offer complimentary consultations to anybody from any company that's thinking about hiring or sponsoring an immigrant. And you all have our contact information already, but we'll be sharing that again at the end of today's webinar. So, okay, so immigration law is massive. If you're, part of our Alcorn community of, we do a lot of monthly webinars and speaking events, and we have the podcast, Immigration Law for Tech Startups, and the TechCrunch column and the blogs. So we're putting a ton of information out there all the time. This is a very specific niche part of what we do. And so just to couch it and frame it, in the world of immigration law, there's business immigration. In the world of business immigration, there's both temporary status, which is typically called like a non-immigrant visa, like an H-1B or an O-1, where somebody can work for you for a few years doing a certain job. And then there's the world of immigrant visas, which are green cards, which people get through adjustment of status or consular processing. So if we're just focusing on the green cards today, and then if you dive into that further, there's all of these EB 1, 2, 3, 4, 5 categories that all have their own different requirements. But if, for the most part, the way most corporate or business sponsored immigration in America works is that if your candidate is like a bachelor's level, you would do an EB3, which involves PERM. And if they're a master's level or higher, or they have 5 years of progressive experience, then you would look at an EB2 with the PERM process. And so that's what this slide is about, driving down even further into EB2 and EB3 green cards. How do they work from start to finish? So that's what gets us here. So Linda, can you please describe the 3 phases of EB2 or EB3 green card sponsorship for an employee?
Sure. So I think, most of our time and attention goes to this first phase, which we call PERM. And really, this is a phase that you are doing a labor market test and actually advertising the position that's being offered to the foreign national to prove that there's not a qualified U.S. worker. We'll talk about what that looks like and get into the nitty-gritty of it. It's really a Department of labor market test, so everyone just needs to be clear that it's not real-world recruiting. It has some similarities, it has a lot of differences, but that's really sort of that whole phase. Unfortunately, there's a lot of steps within PERM, so that whole process can take 19 months or more, and a lot of it is waiting for the government to adjudicate the Department of Labor.
And we've seen USCIS really step it up in the Biden administration to improve processing times for visas, but that's not what this is. This is Department of Labor, so they have their whole own world, and they're still backlogged.
And they are, and they're not a fee-based agency. So like USCIS, they can just increase their filing fees, and then hire workers. But Department of Labor is pushing for more money in their budget to make their operations more efficient. But as of now, we're kind of stuck with what we are because they don't have the funding and they're not filing fee recipients.
So as economic demand increases, they're not necessarily staffing at higher levels or becoming more efficient. Hence, this backlog has grown over the last several years.
Exactly. Yeah. I mean, I used to see this process happen in like 10 months.
Yeah. It took a few months and you were done. And it was all the internal phases of it.
Yeah.
Like at least 3 separate subphases that we'll talk more about. But PERM is like a complex beast.
Yeah. So that's where we're at.
What?
No, I'm sorry. Unfortunately, that's where we are today.
Yeah, it's good to just be aware of it. And and even, PERM isn't right for everybody. And we'll talk a little bit about it later, but we like to encourage our corporate clients and their people ops and human resources folks like to think strategically. Maybe filing a PERM isn't even necessary, but for people who aren't extraordinary or famous or researchers or whatever, like this is where most people end up because it's kind of the well-trodden path. It's like H-1B, PERM, green card. So what happens after, how does a PERM transform into the green card? What are the next steps after you've?
Yeah, so it really changes hands between government agencies. So everything that happens in the PERM phase is done with the Department of Labor. And once you get approval or PERM certification from the Department of Labor, the case will shift over to USCIS for the final 2 stages. And when we look at those 2 stages, there's different times when you can file those 2 stages together. And that's controlled by the visa bulletin, which is the immigrant visa availability. And then there's other times where there's a tremendously long wait between phase 2 and phase 3 if you're a foreign national that's from India or China. So the timeline can vary greatly.
Yeah, before the pandemic in 2017, the Cato Institute did a study. They estimated that if you were an Indian person with a master's degree in the EB2 category, your spot in line would take 151 years or more to achieve. So obviously there's been a lot of flux, people didn't use green cards, whatever with a global pandemic, but it's still probably, it could be decade. Like if you're hiring a recent college student or master's graduate that has has an H-1B and you're getting them their first priority date through this process, which is a tremendously valuable thing for an employee for India or China to have. They'll be very appreciative and grateful. But they could be looking at decades to actually getting their green card through that process. So from a company budgeting perspective, it also means that you're a hero just through getting through the PERM and the I-140. You don't even have to complete the process and do the I-485s for everybody in the family. So the backlogs mean that companies can save budget, I guess. That's a nice.
I mean, it's a good retention tool. I mean, I think a lot of immigrants want that peace of mind. So having the employer sponsor them, even if it's going to be 10, 20 years to get the green card, they have the peace of mind, the company's happy. I think it's a great tool. Yeah, and what's interesting is when we shift gears and now it's fee-based because we're filing with USCIS. Oh, sorry.
No, sorry.
I was just going to answer a question that we seem to always get about premium processing. Can we expedite my PERM? And, we really can't do anything in the first phase. But when we get to the second phase, which is the middle of the process, we can actually do premium processing with USCIS. And then the final phase is more biographical, adjusting the person's status from temporary worker to green card holder. There's no premium processing there. So you can see the beginning and the end of the process, it's a pretty long timeline. The middle moves quickly, but the rest is pretty slow.
And I like to explain this to companies who are new to it by being like, and this is a very crude summarization, but it's like, step 1, can we replace the immigrant with an American? If not, step 2, tell us what your company is and what job you're hiring for. And then step 3, okay, person from another country, tell us you're not a criminal, a terrorist, a polygamist, you have all your vaccinations, you pay your taxes, great, we'll let you and your family in. Like that's kind of a very crude summarization of how this is designed. But it can help from a company perspective just to be like, oh, that's the purpose. Okay.
Right.
Okay, so let's keep going. So now we're drilling down even further. This is just the PERM. This is not an I-140. It's not a waiting for the visa bulletin. It's not an I-485. It's within the PERM. So what happens there?
Yeah, I mean, this kind of shows the mystery behind that long wait that we talked about, right? So everyone it's frustrating. It's frustrating for us as attorneys too, because we don't like to be waiting on these cases for 7 or 8 months at a time.
We want to get you an approval tomorrow. Like we're lawyers. We want to win things.
We want it to happen fast too, but it is what it is. So, we have to work through these channels. The first thing is really working on that job description to closely define the minimum requirements, the education, the experience, and then that pulls together the prevailing wage request that is submitted to the Department of Labor for them to assess, and they'll assign a suitable prevailing wage based on the job requirements, the geographical location, and the experience level.
Okay. And so like when people are tasked with getting experience letters, can you describe how that fits into this?
Sure. So because we're going to be doing advertising eventually to do this like labor market test for the position, it's really important to be able to show that the foreign national is qualified for the PERM job, because ultimately we're testing the market to say the job requires a bachelor's and 5 years of experience with software development. But if the foreign national is not qualified, the process will fail. So where our preference is, before we submit this prevailing wage request formally to the Department of Labor for the PERM job that's defined in terms of the requirements, we work with the foreign national just to make sure that they're able to get experience letters. We give them guidance, we give them templates to show that they gain the required experience. So they also have to be qualified.
Okay. So the first part is the prevailing wage. We get that document back from the Department of Labor, and then we're empowered to move on to step 2 to help the company with the labor test.
Right. Right. So Department of Labor gives us a formal prevailing wage determination, and it has an expiration date. So we've got to kind of keep that clock in the back of our mind to make sure everything happens during that time period. And then we advise the employer on the recruitment steps. There's some mandatory recruitment steps. So I know when everyone hears the word recruitment, they're like, what? What does that mean? So,
Like, wait, we want to hire this person, not all the
right.
other random people that might show up.
We can't fill this position. We've tried. So I just have to explain that the Department of Labor regulations written over 20 years ago spell out the specific steps the company must take to perform a labor market test that's considered fair. So going back to those regulations, some of the requirements include, two Sunday newspaper ads, a physical posting at the work site, a state job bank posting. And then you have to pick 3 other from a list of 10. But, so when you start to hear those recruitment options, the employers just look at me kind of strange, like, I have to run Sunday newspaper ads,
Yeah.
This is what's required. And this shows that you're acting in good faith and compliance with the regulations.
Yeah, that's a very helpful distinction. Your goal as a company acting in good faith is to accurately and adequately comply with the test, the labor market test.
Mm-hmm.
It's not that you have to literally hire different people.
No, but if you have openings, like let's say you have a job that's really hard to fill and you are advertising it and you find someone and you want to hire them in addition to the foreign national. So we can actually run the ads in the plural. Software developers, right? The companies, I'm looking for 10. I would love to find somebody in this process.
That's great. So then maybe this budget for these ads actually helps you fulfill your hiring needs. Potentially, it could be win-win.
It can happen. Yeah,
okay.
It's possible.
Okay. Amazing. And if we structure it the right way, then the company won't be disqualified if good candidates show up who they want to hire in the process.
Yeah, but practically speaking, looking at where we're advertising, you may just get a handful of people applying, if any. But what the employer's job is to do next is to look at those candidates and evaluate and determine if they're qualified U.S. workers.
Yeah. And now this is something where we have to be really careful, right? This is not a lawyer's job and we can't do it for you. And there's been a lot of case law because people got into trouble for doing that over the last several decades. So we really have to, but you tell people how they do it, how they need to do it. So you and your company will feel empowered to adequately do it. But this is something that your company has, or clients' companies have to do.
We actually give you we help you formulate the questions that you'll need to ask. We don't ask the questions, we don't evaluate the candidates, but we give you a candidate assessment form. So you know exactly what the requirements are. There's some questions you can and can ask about whether they're U.S. workers. Are you authorized to work in the U.S.? Do you now or will you in the future require sponsorship? If they say, I need sponsorship or I don't have work authorization, you can disqualify them. Because again, we're trying to test the labor market to prove there's not a qualified U.S. worker.
Yeah. And I just want to reiterate, because we got the question, this is recorded. You will all get a copy and we are available to have complimentary consultation with anybody who's not yet our client in the audience to talk about your company's immigration needs. So thanks for that question. Okay, so let's say we're done with the evaluation. We either, did it in plural and we're lucky and we found an extra person who we get to hire, or there wasn't anybody. What do we do next?
So then as the law firm, the case shifts back to us. So we get all that recruitment evidence compiled. We ask the company for the physical posting that they ran. And then we take that and we start to draft the PERM application form, which is the 9089 form. This form has recently—
This is like the real PERM. This is the thing that's actually the PERM.
Yeah, that's where the whole name came from. This is the PERM form. And they changed it recently, but it's 15 to 20 pages long. And we are summarizing everything in the four corners of this form. We're describing the job's requirements, the foreign nationals' education, experience, and how they're qualified. And we're also describing all the recruitment efforts that the company has undertaken. And it's really attestation based. So we're not providing the Department of Labor with a stack of evidence. We're just filling out this form, and then the company is signing off to agree that, we followed the steps properly. This person's qualified. We couldn't find a qualified US worker. And that gets submitted electronically to the Department of Labor.
It's a very different standard. Department of Labor believes people and requires them to certify their truthfulness, and then they go with it, and they don't need a bunch of paperwork necessarily. But they'll hold you accountable. We'll talk about audits a little bit. And then whereas USCIS and a lot of immigration petitions are like a preponderance of evidence standard where like you have to prove it's more likely than not that this is accurate. So it's a very different world that we operate in with PERM compared to the other types of visas and green cards we do. Okay. Yeah, can you touch on some of those sub bullet points for number 3 about like,
Sure.
What's a priority date? Where does it come from?
Yeah, so the day that we submit the PERM application form, we do it online electronically. The moment we submit it, we'll get a notification, and that date is called the priority date or the filing date that attaches to the foreign national in this process. So that's really important to be able to know. We do share that with our clients right away. It's been filed. This is processing time. The other kind of really important variable, and it will play into when we look at the visa availability along with the priority date, is the employment-based category. I know we hear EB2, EB3 all the time. And when you're looking at immigrant visas or green cards, you have family-based categories, and then you have employment-based categories. Within the employment-based categories, you have different preference levels. So for PERM, we're looking at second employment preference, and that's for jobs that require, and it's really the job, not the individual's qualifications. The job has to require a bachelor's in 5 years of experience or a master's degree. Sometimes you might even have an alternative, bachelor's in 5 or master's in 2. That's fine. Both requirements have to meet that minimum threshold if you have 2.
Great. And then how hairy is an audit? When do they happen? Can you like do certain things that will definitely be an audit trigger? What are they?
I wish there was like a magic potion you could like sprinkle out there to prevent it.
I mean, I heard at one point that like pretty consistently, maybe like 10% just tended to be audited. Like they have some number that they're filling because they want to make sure people are acting in good faith.
Yeah, I would say that, but there's also triggers, right? So we know from being experienced attorneys what's going to trigger an audit. So, if we're going to require a bachelor's and 20 years of experience, you're basically saying, can you please give me an audit, right?
Yeah.
Because they see that as, wait a second, is this a fair labor market test? Do you really need 20 years of experience for someone to fill this job? So those are some of the things that we as attorneys, before we get to the prevailing wage, we're assessing and we're advising,
We're going to be thinking about that from the first time we talk to you about, okay, what's this job? Who do you want to petition?
Yeah. And then there's like foreign language requirements. Okay. So that's something we have.
Like you can't require them to speak both fluent Mandarin and Swahili. It's probably not going to work.
Yeah. And even when you require it, I did it once for a Mandarin teacher at a high school, and I got an audit saying, why do you need a foreign language? I'm like, did you read the job title? So, it's something I feel like it's an automatic audit. In many ways, it can be an automatic audit. So we just have to be prepared with the evidence to demonstrate why it's needed. But we would advise you, look, there's a risk. If you want to take that risk, we can move forward, but it's going to delay the case. Audits can delay the case 6-9 months. When you get an audit, you have 30 days to respond. So on our side, when we're filing the PERM application, we're actually creating an electronic audit file. So we're ready. And so if we get that audit, we can quickly jump in and respond within those 30 days.
Yeah, because you never want to leave it to chance of like, oh my God, it's an audit. Quick, find everything. What did we do? I
Oh,
can't
yeah.
remember. Where is it? It's in my email. I don't know. It's in the Slack. Disabled the Slack channel. I don't know what happened. Yeah, we don't want to do that.
Yeah,
So.
no.
Okay. And we have a live question from Hoon. Thank you. Linda, can you clarify? There was a question about somebody has a bachelor's degree. Is there a minimum number of work experience years that is required? We touched on that, but there was a question for clarification.
For sure. So in that context, when I mentioned the bachelor's and 5 years of experience being a minimum threshold, that is for the second employment preference, EB2. The other category that a PERM can be filed under is EB3, or the third employment preference. And that's for professional jobs that could require as little as 2 years of experience and all the way up to a bachelor's and 4 years of experience.
Great. Thank you, Linda, and thank you for
Sure.
that question. We love making this interactive. So thanks for asking questions, you guys, because we like knowing that, you know, our words are landing. We can't see your faces or your Zoom thingies, but it's nice not speaking into a void. So thank you. Okay, so let's assume we get through all of that. We've submitted the PERM. We've waited 7 to 8 months have passed. There has not been an audit. What does it mean to be certified and what happens from there?
Yeah, so if the PERM is certified by Department of Labor, that PERM form, the 9089, gets printed and signed electronically by the Department of Labor. And then you have a validity date stamped on the bottom of the PERM form. It's valid for 6 months. And then you can move forward to the last 2 phases of the case, the I-140, which we spoke about, and then the 45.
Yeah, that's great. And then if this is somebody's first PERM ever, you take the date the PERM steps, the 9089 was filed, and then you put that into the I-140, and once the I-140 is approved, poof, that original date magically becomes their priority date. So so if somebody quits in the middle of their first PERM, they're not getting that priority date to take with them. If you're certified, but you never get around to filing the I-140, don't get to keep the priority date. If the I-140 is denied, don't get to keep it. So that's a little bit of how it works. Yeah.
Yeah. And sorry, go ahead.
It's just if somebody already has a priority date from another company, then it doesn't matter. We can reuse the old one if it was EB1, 2, or 3, but otherwise it matters a lot to people.
It does, yeah. Priority date's important in the employment preference category. Those 2 things come up a lot, and I see some questions here that relate to that.
Do you want to talk about this now, or do you want to do it at a later point? It's basically about figuring out which category to put people in.
I think maybe before we switch into layoffs, just because we're going to feel like we're switching gears a little bit. And you know, the advice I always give companies is you always have to look at the job's minimum requirements, not the preferences. So if it's a senior engineer and the job requires a master's degree or a bachelor's in 5, that's a very clear EB2 job. If it's an entry-level job, it's much harder to require a bachelor's in 5 for that type of job. So I think it's really, you really have to look at what the company's typical requirements are and build off from that. Maybe it's a specialized job and you do need to require a master's degree. So we have that conversation with the company and we, you know, try to weigh out all those factors.
We think about it. We think about positioning the legal arguments to have an approvable case based on the company's needs. But if you, I mean, you're not going to randomly start this process of like, we want to be PERM ready. That's not how companies do it. They're like, we want to sponsor this person for a green card. Linda, what do I do? So we have a process. Once you become our client and your company has signed our client services agreement, we can do unlimited visas and green cards for your team members. We have a questionnaire. You know, they fill out our information. Linda will have a meeting with you and be like, okay, for this person, let's talk about the company's needs and what that role is. And then Linda's thinking, okay, what's the best way to position this PERM, but for a specific person? And we're not like doing it in a vacuum or anything. So if you know you're trying to get this person a green card, we'll help you optimize for them. But we have to think about it the way the government's thinking about it. Okay, great. Okay, well, let's talk about layoffs. I mean, now that we have that perm background, which I think is super in-depth and helpful and clear, where the big question arises, all right, well, we just laid off a bunch of people, but now we got to keep these other people. So like, how do we get them their green cards? Because are we not allowed to do green cards now that we did a layoff? So let's transition into that. Okay, so we talked a little bit about audits already, but let's talk more about that, Linda. Can you walk us through these perm audit triggers, please?
Or so, particularly with larger companies, if there is a layoff or a reduction in force, and the Department of Labor is aware of that, if you're filing perm applications for that specific job, you could get a layoff. It's possible, but it's not always going to happen. But you do have to be aware that their radar is up. Foreign language requirements, we talked about that. That's pretty much an audit most often. The other thing that I think is important is
it just makes me think like in the 80s or whatever, 1992, they were probably doing so many like, oh, we need a blah, blah, blah speaking so-and-so for this role. It's an absolute requirement. So many people probably got through it that time, but obviously they were like, wait a minute, protecting Americans.
Yeah, I mean, and also I think because it's a US worker, so I think it feels like, you're basically giving the foreign national an unfair advantage. So you really have to be able to demonstrate why the job requires a foreign language.
Yeah.
And it's I do see it both sides. It's a tricky requirement. So I just always advise people when they want to include it that like, let's talk about the business justification.
How does the government get aware of reductions in force?
So there's under the WARN Act, isn't there a notice that gets filed? Maybe you know a little bit
Yes.
more about
So
that. I don't know the
big
mechanics.
companies do have to file official notices. There's also newspaper articles. They're humans, they read the news. And like there's spreadsheets like layoffs.xyz where people are like self-reporting and providing their contact details to try to get a new job, as well as their immigration status on these like public spreadsheets last fall. And you're like, wow, that's a lot of confidential information, but okay.
Yeah.
So that's floating around. These are humans who pay attention to what's going on. So like you shouldn't, you can't try to like hide the fact that you had a layoff if you were thinking about doing that.
Right.
Yeah. And then this comes up for startups. This is like a big reason why we don't do perms for startup founders. Can you talk about the employer-employee relationship?
Yeah, this is a really important point to stress, because if there's an ownership interest, and we're talking something like beyond nominal, like we certainly see people that have 0.05% interest.
Yeah, I think like advisor level equity, founding engineer equity, you might be able to get away with that level, like 1-2% at most, probably.
Yeah. Right.
Yeah.
But as that increases, then you run this risk of an audit. And because if they don't think that essentially the company can terminate you, that you're really not an employee of the company, Department of Labor has its own standard, and they might think that this is not a good faith recruitment. If there's 3 people that work for the company, and the person who sits in the desk next to you is running the ads, the other person's making the decisions, the small, closely held.
And the person who's making the decisions is your brother.
Right. Yeah. So all of those are considerations, and that's what we would advise on. So we will pivot at the end of this presentation to talk about some other ways to get a green card, and if you're not qualified for the firm.
But like most companies in the technology vertical, or those that are hiring engineers and other professionals, they're not like a dry cleaning family owned business that has a language requirement. So it's mostly just about how we can get through this as efficiently as possible, because it's a real business need. It's a real company. Yeah. Okay. And then what are some examples of like an unduly restrictive perm requirement that's not necessarily language related?
Yeah, I mean, I always use that bachelor's in 20 years of experience.
Oh yeah.
And I've had to talk people out of that more times than I can tell you. Yeah, for like executive level roles. And I understand that you can make a justification, but Department of Labor has all these resource materials like the Occupational Outlook Handbook. And it will spell out for occupations what's like minimum entry into the occupation. And then there's also standards for how much experience different occupations should require. So that's part of what we're doing on the front end at the
Another, it's a translation in thinking. We're shifting it from business need. That's not the right perspective to win one of these cases. It's actually based on the government's perception of the economic needs that should drive the business. And so we have to put on that hat to help this forward. So it's like
and
very
it doesn't feel logical to people sometimes. So
yeah. Okay. Okay. So let's talk now about PERM layoffs during the recruitment window. So now we have that specific, there's timing, there's phases, there's the process. So if the layoffs happened at specific parts in the process, there's different consequences.
Yeah. And I think one of the big questions is, you know, the layoff, I'm either about to start my recruitment or my recruitment has started and now there's been a layoff. And so the company really needs to make a decision at that point, what they want to do. The way the PERM form asks this question, it's very specific. So the way the form reads is, you know, in the 6 months before you're electronically filing the PERM form, did you lay off a U.S. worker in the area of intended employment in this occupation or related occupation? So you've got to think about satisfying all those 3 parts. If you answer yes to that question, you could get an audit, and then you can make a decision. If you answer yes, you could still file, but you have to be able to show that you in good faith gave notice to the laid off US workers and considered them for the opportunity. So you really have to reach out to them by email, offer them the position, or tell them that do they want to be considered for the position.
Right. Okay. Anything else you want to add for this slide, or shall we go?
Yeah, I mean, I think what I always tell companies is when we know the layoff is going to happen, that PERM prevailing wage, oftentimes it's valid for several months. So the wages turn over every year, July 1st. So when you get a prevailing wage now, it's going to be valid through June 30th, 2024. That's when the new wages are going to come out on July 1st, 2024. So you have time to pause the recruitment, wait on the recruitment, and work it out so that you're getting the PERM filed 6 months after the layoff. So you look at that layoff and you do a time assessment.
Is there another element to seasonality where if companies are like, oh, we're going to start doing, 10 or 100 or 1,000 PERMs a year, like what's the annual cycle that company ought to think about for compliance?
Well, I mean, I think in terms of like cycles, I mean, when you do a labor market test, the summer and like November and December, things are, I would say there's less people actively looking typically. So, if you try to be strategic about it, you could start your prevailing wage knowing that it's going to come out and you can be able to run your recruitment in the summertime or, November and December.
When
the labor market
based on the current processing times to those opportunities.
It's hard though, because, we don't have so much control over how long it takes for Department of Labor to issue the prevailing wages. Sometimes it's 6 months, sometimes it's 8 months. So it's a moving target.
Yeah. Okay, wonderful. Okay, and so now let's bring this back because now we're looking at the visa bulletin. So how does this tie together?
Yeah, so we walked through, the PERM process. We took that deep dive and then we stopped and we talked about audits and layoffs. And now we're going back to the beginning, right? We've got the PERM approved. What happens next? So what's really important here is to look at the Department of State's visa bulletin that gets released every month. We've taken an excerpt from the employment-based section under the final action dates for the most recent visa bulletin. This really tells you when you can proceed to the very final stage of the green card process, the 485. So we're looking at 3 different variables. The first one's going to be that employment-based category, EB2 or EB3, and that's to the left, and that's really depending upon what the PERM job requires. The next thing we look at is the foreign national's country of birth. So you can see across, we've got China, India, Mexico, the Philippines, and then we have this catch-all, all other category. So you look at your country of birth where it matches, and then you see a date in that column. So if you look at India, EB2, the date is January 1, 2011. So that means if someone's an Indian national and they filed their PERM under EB2 before January 1, 2011, they can now proceed to the final stage of the green card process, the 45.
Right. Okay. All right. Okay. And then, so I'm just thinking about how we're doing on timing. So we have about 15 minutes left. So, and I do see, a question, but definitely if you have any like burning questions that you were saving for Q&A time at the end, add those now so we can kind of gauge and track our timing so we can make sure to answer all those questions for you. And we definitely also want to talk about some alternatives that don't involve PERMs. So we have some slides about that. But can you just walk us through like what the company has to prove at these I-140 and I-485 stages? Because that can be tied to economic forces and profitability and things like that.
Yeah. So once that PERM is approved, you have a 6-month window to file the I-140. And in some cases, you can file the 45 concurrently. But in terms of the I-140, the employer's responsibility is to show that they can pay the prevailing wage rate. And that could be in the form of tax returns. Sometimes it's just showing the person's actually received that salary in their last W-2 is enough, and recent pay statements, audited financials. If the company has more than 100 employees, you can get a letter from like a financial officer saying the company is financially viable. So that's sort of what we need to be able to demonstrate from the company side at that phase.
And all of that said, we get pre-revenue early stage startups approved for I-140s all the time. So even if a company is going through some murky times with cash flow and finances that led to layoffs, like we get companies that have zero revenue approved for green cards.
Yeah,
so,
and you can also, you can be creative.
Yeah.
And you can also take the net current assets off the tax return. There's case law about that. So you can use all these different formulas. And I've included bank statements for small companies before, just to show what they have in the bank. But the gold standard is going to be tax returns and audited financials. And then all the other alternatives we definitely would look at if we don't have strong evidence in those areas.
Great. Okay. And so we help a lot of companies, like even if they're not having layoffs, they may just like be motivated to help their brilliant employees get green cards as quickly as possible. And it's actually faster and cheaper to use other pathways if beneficiaries qualify. So a lot of what we do is recommend non-PERM options anyway. But it's like PERM is tried and true. It's famous. Everybody knows it. Every international college student is like, oh, get in the H-1B lottery, get a job, get the company to do your PERM, your I-140, get a priority date, wait in line, do your green card. Your life is golden. So that's kind of like what most of the million international students every year are hoping for. So there's a lot of demand for it. And it's what a lot of the big, like Fortune 500 companies, big tech companies are set up to do for most of their volume-based immigration that they help their teams with. Like, it's not the only way. And like, you don't have to be like a serial founder with multiple $100 million exits to qualify for these other options. So a lot of our Alcorn education is like EB1A and PERM for startup founders, but there's a whole giant swath of people who are very diligent and smart workers working in big companies that might qualify for these other options that don't involve PERM, and you don't have to be the next Mark Zuckerberg to qualify. So it can be very helpful and fast, and like all in all, if you do all the phases together, like these things are cheaper for one person than adding in the PERM process. You like save a year. So
Or two.
Use these where possible.
Yeah, and people are running out of time. If you're, let's say if you're an H-1B worker and you're running out of time and you've got to get that I-140 approval, you can't wait 2 years to go
Yeah.
through the PERM process.
So just super high level, I'll just say what these are. EB2 national interest waiver is the same EB2. So it's like the master's or higher, the 5 years of progressive experience, and the national interest waiver portion specifically, now that you know what PERM actually is, the national interest waiver is a waiver of the PERM requirement because the person's future contributions to the United States are so valuable, they're in the national interest, and therefore we can skip the labor market test because even if there are Americans, having this particular individual is worth it. And we've even gotten these approved for like power linemen fixing the electrical grid in like forest fire situations. So it can be really random what's in the national interest. Like we can make lawyers, it can make a lot of arguments. The EB1 category is the fastest category for people born in India or China or anywhere in the world, but it matters more for people born in those countries. EB1A is extraordinary ability. EB1B is researchers. You can have a research team, a department in a company, and then your researchers can get EB1. EB1C is multinational managers and executives. It's like an L1. It's like if people transferred from your foreign branch to your US headquarters, you know, they could potentially qualify. So none of these involve PERM. It's simply file the I-140. Premium processing is available for all of them now too, which is the other amazing thing. EB1A is 15 days, EB2 NIW and EB1C are 45 days. So we've even had situations where people are like, oh my God, I just got hired and I never got a priority date and I'm almost at my 5th year or my last year of my H-1B and I really need those AC-21 extensions to keep staying here before I use up my whole 6 years of H-1B and lose the chance. Quick, how do I get an approved I-140? And you're like, well, you're from India, you're gonna have to wait, who knows, God knows how many years. But it's like, no, let's just do an EB2 NIW now with premium processing to just do whatever we can to get that A, priority date, and B, the approved I-140 to open up the unlimited H-1B extensions. So we can use these tools in a lot of ways. Like just because you get it, like we might do an EB2 NIW I-140 for somebody knowing that they're never going to use it to actually get their green card one day, but it helps get benefits in the short term.
And I think exactly what you're saying, you know, we see people who get a PERM and they're maybe from a backlog country, they build out their profile more, and then they decide, okay, I'm qualified for the EB1A. You save that same priority date, and now you're attaching it to the first employment preference, and the line is much shorter, and sometimes it's even current. So you reduce your time from 10 to 20 years to, you know, 1 year. So.
And the other thing that I will say is that the visa bulletin has been in the news this summer because it majorly got backlogged. So everybody freaks out whenever that happens. But that's normal. That doesn't mean green cards are suddenly bad. It's just there's more demand than supply. Every year they run out and then every year they reset. So they're going to reset again on October 1st because that's when the government fiscal year opens. So like green cards can get a bad rap because of that. It's like, no, just like hold your horses, a few more months, there'll be another news cycle on how there's suddenly, you know, hundreds of thousands of green cards available and all the categories jumped ahead. That happens every year. So, okay. So we can help you with those. And then also, you know, if you have team members who are like, wow, they're so amazing, we want to help them. They can't get their EB1 yet, but we would like to support them. And maybe they're doing research or they're creating disruptive technologies or whatever. You can literally help your team members, especially from India and China, get qualified for an EB1A. One of the candidates' most challenging problems is they're not allowed to do outside work. So if they're hyper motivated to get an EB1A to speed up their green card process for themselves and their families, they're kind of between a rock and a hard place if what they're doing isn't public, because they're trying to like rack up that portfolio of accomplishments. But we have a lot of companies actually support their employees to get the like PR opportunities to showcase their work publicly. It helps our company's marketing and branding message because their work gets famous and the people who are benefiting are super grateful. And we have a class for Extraordinary Ability Bootcamp, which is our online class about to be renamed to Alcorn Academy Extraordinary Ability Prep. But anyway, this is our online class and you can offer it to your employees to help them become qualified for an EB1A. Great. So if you need our help, please email us hello@alcorn.law. We would love to schedule an appointment with you. We offer complimentary consultations to people from companies who have immigration questions. And with that, let's look at some of these questions. So first up, this is a little bit more about advertising and PERM and how you are setting up the role and how you describe the experience. So this question is, would they only count work experience relevant to the role we are advertising through PERM, or could it be any work experience? How strictly is this requirement checked for? And would school internships or work experience abroad, freelancing projects, would that count for this requirement?
So for the work experience requirement, you will have to provide an experience verification letter. So that's just something to be mindful of. It could be experience that you gained during your studies. But if that was during curricular practical training, we can't use that because that was something that you did to get your degree. So we have to kind of look at it very carefully. When we have the PERM experience requirement, let's say it's 1 year of experience with software development, we can expand that and say, or systems analysis, right? And maybe your experience is more with systems analysis, less with software development. So as we work on that PERM, we do evaluate what you have for experience as we put together those minimum experience requirements. And then we don't proceed with the prevailing wage until we know that you're able to secure those experience verification letters.
Great. Okay, thank you. We have a few more minutes, so any more questions, type them now or forever hold your peace or just contact us. Okay, next question. What would be the best option for H-1B employees with 1 year left on H-1B? If we start the green card process, can their time on H-1B be extended past expiration? Yeah, can you speak to that, Linda?
Yeah, definitely. I think Sophie talked a lot about PERM alternatives. So because the PERM process can take 2 years or more just to get to I-140 approval, and you really need either the I-140 approval if you're past your 5th year of H-1B time in order to get more H-1B time.
However, we can do the recapture analysis. So if that person was ever like stuck outside in COVID when they were on their H-1B, or they traveled for business trips or vacations, we can try to recapture any time they spent out of the United States to recalculate when that anniversary is actually happening.
Yeah, definitely. We have a whole chart that we have them fill out to see if there's time to push that 6-year timeline. And, if they're a good fit for the PERM, we can make it happen. If not, we can look at those alternatives, the EB-2 national interest waiver, EB-1A, and see if they're a good fit.
But okay, let's take this to the extreme. Let's say there's like a critical person and like they just got hired and they're SOL, like it's clearly, 5.5 years and there's no way that they're going to meet any of those AC-21 extension requirements for H-1B. Could we put them on another type of work visa?
Definitely. Yeah, I think this last slide here gives us some of the options that we can look at, but maybe if they have a lot of documented accomplishments in their field, we could look at an O1. That's a possibility.
What about the 1 year? What is the 1 year requirement for after somebody's H-1B completes? And I'm putting you on the spot because I can't remember the details, so we can look it up for anybody if they want. But there's something where like you have to be outside of the US for a year after your 6th year on the H-1B before you go through the lottery again.
Yeah, so you could restart your H-1B clock, but you'd have to be physically outside the US for 1 full year, and then you'd have to get selected under the lottery and then file.
Do you know off the top of your head if we could transition somebody to a cap exempt H-1B without going through that 1 year waiting period?
No, so the time you spend in your cap exempt H-1B counts against the 6th year.
Okay, so we'd really have to, and I think L visas carry additional restrictions if somebody has used up their time in H-1B. So we might want to look at maybe an O1 for somebody in that situation and how quickly can we get them qualified for that. And those are being more, those are being more favorable to for like adjudications on O1s are more favorable now in this administration towards STEM candidates.
Mhm.
So like there's options. Okay, and then final question. When do travel restrictions come into play for your employees during the 3 phases of the EB2 or EB3 PERM, I-140, and adjustment of status process?
I think the biggest variable is what is the individual's underlying temporary non-immigrant status. So if they're an H or an L, they have almost no restrictions. We just simply need to file when they're in the US. They don't need to get special travel permission. But if they're in another category such as TN or O, then you have to make sure that they get travel permission at the 45 stage. So you've got to wait like 6 months sometimes to get that travel card, and then you can travel and not abandon your green card application.
And in the Trump administration and the pandemic, as out of an abundance of caution, I was even advising H-1B holders, like, look, if you're filing the I-45, just be extra safe. Just wait till your advanced parole comes. So that would kind of restrict somebody being in the US for like the first 6 months after their I-485 is filed. That's pretty universal. The other thing would just be if they're on, look, you can sponsor F1 OPT students for green cards. It's just, that's a non-immigrant visa. So their travel is potentially going to be restricted after that if they're on a non-immigrant visa. So TNs, from Canada or Mexico, E3s for Australia, H1B1 for Singapore. Those are all very strict non-immigrant intent status visas. So if you want to sponsor them for a green card and they've already been in the US for a few months and they can just stay here, fine, you can start their green card. But it's where there's a need for international travel that it can be messy if they had a non-immigrant visa, because then we have to wait till they can get their advanced parole. But I've had like Stanford postdocs that got sponsored for 3 green cards at a time, just as a race to see which one would be fastest. And they're like F1 and they can't travel, but it's like, you know, top secret, whatever they're building, they have to be here. Everybody's so motivated. Okay, one more question. Following the PERM process, does the I-140 need to be filed 1 year before the H-1B expiration in order to extend past 6 years?
No, it doesn't. And thank goodness we have premium processing. So all you need is that I-140 approval in hand before you reach your 6th year. When we talk about that 1 year requirement, that's specific to the PERM. So there's 2 ways you can get H extensions. One is if you file your PERM application when you have at least 1 year of H-1B time remaining. But the I-140, there's no time restriction.
Great. Okay, so if you're on this webinar and you were interested in information for yourself, we can do paid consultations to help you define your legal strategy. If you need, you know, legal advice or information about like trying to map out your own story as a beneficiary. And if you're from a company, you know, we're happy to talk to you. We can offer complimentary consults. So please keep in touch. We'll be emailing everybody the recording next week. And thank you so much for attending today. And thank you, Linda. This was wonderful.
Thank you, Sophie. This is great. Have a great weekend, everyone.
Have a great day, everybody. Bye-bye.